those international treaties and covenants. Uh, Mr. Yap Liang from Singapore, he shared with us how these human rights in the business practices can be introduced. He also shared with us the state action plan which should be there. He also made a point that companies should be held responsible for the breach of human rights, and also he gave a red flag saying that there will be international pressures, and therefore now before all of you ask a question, there is a one question, single line question to all four panel members, and that question is, ultimately we are lawyers, we are student of law. In our different jurisdictions, we have seen how soft law and hard law have been implemented for years together. So let me ask that common question to all four panel members. The first is Sri Lanka. The question is, what about the human rights of the lawyers and how you have implemented these different principles in the Sri Lankan context? The same question will be thereafter to Mr. Jason, who will share from Taiwan experience, then Mr. Anar from Mongolian experience, and then the President-elect of the Law Asia. He will be speaking about this particular topic, namely how you are looking at the human rights of the lawyer. Rajiv.
Thank you, Dr. Uday. It's an interesting question. So from the point of view of the Bar Association of Sri Lanka, one could possibly say the Bar Association in Sri Lanka is the most influential civil organization in the country. So therefore we wield a lot of influence in what takes place. We have 92 branches across the length and breadth of Sri Lanka, 65,000 square kilometers, and we have lawyers everywhere. So if there is any problem the lawyers have, we are a formidable force. Now, if the principles governing the Bar Association vis-a-vis lawyers and of course the citizens is principles of rule of law, due process, the independence of the judiciary, human rights, and of course the wider rights and interests of the lawyers. And so if there is any point where we see that there is some infringement, curtailment of rights of lawyers, whether it's human rights, whether it's beyond, then the Bar Association would intervene. Of course, we draw the line in this way. We intervene positively when it has to do with professional duties and professional work. If you have lawyers engaged in other occupations, say even politics, and then we are a little careful on intervening and limit it to the professional duties and of course the general rights as citizens. Now there was an interesting incident which took place. I took office on the 29th of March, as I mentioned, as president of the Bar Association. That was a Saturday. And I had the convocation, a large event, where I was inducted. The day before, there was a lawyer in the Puttalam High Court, that is about 3.5 hours from Colombo, a lady lawyer. There had been a dispute between the lawyer and the judge for a little bit of time. And somehow on that day, she was remanded for contempt of court on the basis, one of the charges was that she had not bowed to court. And of course there were also the disruption of court and so on. Basically that was the crux of the charges. When she was remanded, I was not president, of course I was informed. I took office on Saturday evening at some of you who had come to Sri Lanka know, the BMICH is the largest conference hall. In the morning on that day, we had the first Bar Council meeting and one member raised this issue, a couple of members raised this issue. And anyway, we were apprised, I had received the call the previous day. And it was also a long weekend, it was a Ramazan weekend. So it was a long weekend, and Puttalam is a district where there is a larger Muslim population, so a lot of administrative work stops. Another issue which came up was that though the judge had imposed bail conditions, the conditions are very difficult and impractical to satisfy at 12:30 in the afternoon. It was not simple conditions. So it was physically not possible. She was remanded. So on Saturday when I took office, she was remanded. What do we do? So it was Saturday, Sunday, and Monday were all holidays. We filed papers. We decided, the first act I had to get involved with, we decided to file a writ application, habeas corpus, and to combine with a certiorari and prohibition, challenging the judge. The judge was one of the first respondent, the charge sheet, and the order of the judge remanding on forced bail conditions and having taken this lady into remand custody. We made a request of the President of the Court of Appeal. I spoke as President of the Bar Association and requested that the court be opened on the Ramazan day. The President of the Court of Appeal was a Muslim. He was Muslim by religion, but he agreed to my request, and he convened the Court of Appeal on a public holiday on Monday. So the papers were tendered to the registry just before. The Attorney General also sent in a representative on our request, because the respondents had to be represented. And I was the petitioner in the case as President Bar Association. We had a team of members who went in and supported the application. And notice was issued and a stay order was issued, staying the remanding of the charge sheet and the consequential decisions. Then, of course, as President, and there was also concern whether, since it is a public holiday, even though the order was issued, whether it will administratively take place at the prison to release her. So, given that it was a one of our members, I traveled to the prison and went and met the superintendent of the prison. We carried the order, and she was released. So that is the type of intervention we do in respect of rights of lawyers, human rights of lawyers.
Thank you, Rajiv.
One of the members from the Bar Association of Water Council wanted to say something against.
Can we take his question after 3 or 4 minutes? There are 3 more speakers. They will speak on this topic. Jason, your experience about protecting the rights of the lawyer.
Okay. The basic norm for lawyers in Taiwan is the Attorney Act. It was enacted in 1941 and was overall amended in 2020. No matter the original one or the amended, the Attorney Act upheld the autonomy of lawyers. That means self-regulation. So, all lawyers, practicing lawyers, are mandatorily to be members of the Taiwan Bar Association. It was established after the 2020 amendment. And in addition to the requirement that each practicing lawyer must be a member of a local bar. So, I think that the very important part is that we say the autonomy of lawyers. I think that's the concrete base to protect the basic rights of lawyers. As for the lawyers' rights, basic rights for our practice, especially for criminal proceedings, these lawyers' rights are enacted in different procedure acts, Criminal Procedure Act, Civil Procedure Act, Administrative Litigation Act. All of these proceeding legislations clearly promulgate the attorney's rights, and especially for criminal proceedings. At first, when a person was interrogated by the police, he or she had no right to seek the assistance from the attorney at first. Then later we extended it to, okay, so during all investigation procedure, from the police to the prosecutor's office, every stage, each person can find attorney to protect her or him. It was, that's the endeavor of, from many lawyers to make this happen. And there are several cases happened when attorney practice tried to protect her or his client, but was stopped by the police or by the prosecutor. And for these cases, we bar support these attorneys to file suits and even file to plead to seek the constitutional court's explanation and decisions. And so now we try to make it concrete and expand lawyers' basic rights to protect clients, especially during the criminal proceedings, especially before the court hearing procedure. These are, we say, maybe hard laws, like the topic we say today. These are hard laws. And as for the soft laws, we have local bars and the national bar, the Taiwan Bar Association. And for each local bars, they annually has the exchange meetings with the district court and the district prosecutor office. Exchange opinions, and we also raise some issues for our practices, so that some problems can be resolved in this kind of exchange meetings. And in national level, with Taiwan Bar Association, we also have annual exchange meetings with the judiciary and the Ministry of Justice, respectively. So these are, maybe we can say, soft laws. Like this way, we can resolve some practicing issues through this kind of meetings. This is Taiwan's experience.
Thank you, Jason. Now let us go to Anar in a quick, maybe 1 or 2 minute, how human rights of the lawyers are protected in Mongolia.
Okay, so in Mongolia we have also Attorney Act ratified by the parliament in 2019, and similarly to Mr. Rajiv said, and similar to Mr. Jason Wu said, it's an unified membership organization, independent professional union, self-governing body. We do not have any composition or delegates from the Ministry of Justice as comparable to some of the jurisdictions. And there are certain sufficient legal guarantees provided under the law. So also there is a code of conduct for professional activities has been also been released, approved by the Mongolian Bar Association. And also in criminal code we have protections for the attorneys to have immunity against investigation, to sustain their lawyer-client relationship privilege and other secrecy requirements. And also, interestingly, we haven't yet practiced this legal potential, but Association of Mongolian Advocates is entitled to bring claims to protect the interests of to common and individual interests of the attorneys before the court if they deem necessary. So it's, and also, very few, that might be interesting is that there has been a latest case where I served as attorney for the lady attorney, and she was, she received a disciplinary penalty for, being blamed that when the case was not yet resolved finally, she made a public statement against a beauty clinic who made an omission during surgery and caused the blindness to the client. And she made certain warnings to the public that you should be careful about receiving the service of this beauty clinic. But then the disciplinary penalty was annulled by the court. And during the court, that court decision, accepted, how to say, recognized the attorney as a human rights activist. So we have a new law as well on the protection of human rights through human rights activists. So in Mongolia, the lawyers became officially human rights activists. Yes.
Thank you, Mr. Anar. And let us go back to the President-elect, Mr. Liang from Singapore.
Thank you. Well, when we talk about human rights for lawyers, we go to the UN Basic Principles on the role of lawyers. And Law Asia, if it's brought to our attention, or from bar associations in which lawyers face persecution, harassment, for example, then Law Asia does assist our bar association members to issue statements protecting and to the governments, protecting the role of lawyers. But linked to this, we must also appreciate that there's also the rule of law. And from the larger international organization perspective, this is one of the points I made earlier when I shared, right, on the international community coming together and putting some pressure on the local domestic governments to seize the actions which may affect human rights violations against lawyers.
Okay, thank you. Now the Bhutan brother wanted to ask some question. We have some time, around 5 minutes we have. Please ask, introduce yourself and ask question.
Good morning to everyone. I'm Sonam from Bar Council of Bhutan. Thank you so much, the esteemed panelists, for giving a very insightful talk about the soft laws and the hard laws to deal with human rights. I felt like I'm not doing justice to my jurisdiction if I don't contribute with any kind of comments. And then as well as I have a few questions, which is also very related to the question that is asked by the moderator. To go with first, even from my perspective, I feel like the hard law and the soft law have to go in line with to achieve any any objective that you are looking for. If I give an example in Bhutan, like I have personally shared with so many of you, Bhutan, the Advocates Act of Bhutan only came up in 2003, and then nothing much could have done. Yet the country was evolving with evolving with the world around. And then in 2017, we have amended the 2016. We have amended the Advocates Act of Bhutan, where we call Jabmi Act. Jabmi is the term in Bhutanese language meaning advocate. And then from 2017, the official establishment of Bar Council of Bhutan came up. And that also before that, when it comes to the equal representative, and then the right to attorney for the individuals who are tackling with the cases, though our constitution provides that right, but the representative of lawyers was not at all there in the market. So it came up later on, and then that was also like maybe because of the soft laws and the international treaties, human rights, because of that force that we have come up, and then we are now I think in a good position to represent any kind of client that that come up to us. And now my concern and my question here is related to the question that is being put in by the moderator. Here, like when it comes to the protection of lawyers, though we don't have much number, in number, it's not a big number in Bhutan, yet we are not free from any like the problems. So when it comes to hard laws to protect the attorneys in Bhutan, we also have like Attorneys Act, Code of Conduct, but all these laws only talk about what are the responsibilities and duties of lawyers. It doesn't talk about how the lawyers are going to be protected from the external forces and the problems and issues that are being faced by the lawyers. So, like you said, we also have a culture of conducting annual general meeting, calling the stakeholders and sharing our issues and problems to help us solve that. Now, my question to the panel is, where does the authority of the Bar Council or the Bar Association come to challenge the actions of other authorities, other authorities' actions against the lawyer? So if you could share any insight on that.
Thank you, brother from Bhutan, maybe the youngest bar council. Law is well settled about that, and the bar association or the bar council gets a locus. There is no difficulty, you can challenge the action. Let us go to that young man who want to raise. Yes, the mic, can you pass on the mic or start, please? We are having hardly around 3 minutes. Please try to ask us a short question. You can take this also.
Thank you, Uday, and distinguished panelists. Me Kedar from Nepal Bar Association. Nepal Bar Association has the 4 pillars. Among the 4, human rights is the 1 pillar. Nepal is one of the Asia Pacific regions, one of the country which ratified the international instrument. Among the 9 core instruments, 7 are ratified by the country. In our constitution, in the fundamental rights, most of the soft laws are adopted, even though we have the problem of the enforcement. In principle, we adopted the international instrument of the human rights, but in enforcement, we cannot do that principle in practice. So, in Nepalese context, Nepal Bar Association plays the vital role in the protection of the human rights in the kingship's tyranny period, and in the freedom of press. And Nepal Bar Association legal community, it appeal from the judiciary side many strictures and orders on the issue of the human rights issue. Now we have the questions about the National Human Rights Commission is preparing the human rights defender law. How can we make the human rights defender law? If we have any experience in the Asia Pacific region or international region, can you answer this?
Yes,
queries?
the brother from Nepal has asked a relevant question, but my time is short. Our session will end within 2 minutes. Let us meet in the while having a cup of tea. Yes, brother. The last one.
All right.
I think they can extend the session by a few minutes. I am the next session, so you can take my session few minutes from my session.
Yeah.
So it's okay.
Rachana madam is kind enough to give us 5-minute extension.
We have fewer speakers, so it doesn't matter.
Okay.
Let's
thank
Yes,
you.
we will try to cover
I'll
up that
just
Nepal.
make 90 seconds
I
anyway.
also have a question.
Oh my God.
I'm
Yes,
Jose
brother.
Morley, Hong Kong Bar Association. I think in terms of hard law and soft law, one important feature we should remember is not so much what the rules are, but the mind and spirit of the people who apply them. And therefore, what is also very important is the DNA and culture of those who are entrusted with power. And in that regard, I thought it was quite inspiring. About 15 years ago, we had Director of Public Prosecutions in Hong Kong, who during the time he was in prosecutions, actually did a master's in human rights. And when asked, well, why are you doing this master's in human rights? He said, well, in this time and age, if you want to be an effective criminal lawyer, you need to understand human rights. And I think this goes for every executive in every jurisdiction. In other words, that whenever you exercise your power, it's not because the rules constrain you, but you have that mindset that you take into account other people's rights and responsibilities. Thank you.
Fantastic. This is a contribution from Hong Kong. Anybody? The last will be Rachana madam, but anybody want to add something? Of course, these are the takeaway which we will have to carry and ponder on those different issues. Nobody? All right. Rachana madam.
I don't have a question, but I want to share one experience similar to what Rajiv Amar Surya had said just now. It's a recent experience. I was at that point of time the Vice President of the Supreme Court Bar Association. There was a case where a lawyer had filed a petition. He had e-filed it. The Supreme Court permits e-filing, and also hybrid hearing is also permitted, so you can appear virtually from any corner of the country. So he had filed this petition, especially petition challenging High Court's order. Incidentally, he had filed second petition challenging the same order, but he had disclosed that in the petition. Now when the matter came up for hearing, so the judge found that this order has already been challenged. Although this was registered, it was the duty of the registry to point it out, but since it was registered and placed for hearing, court asked for the lawyer. The lawyer incidentally was far off in some south district. The internet was not working, so when the court asked for the lawyer, he was not available. The instructing counsel, who was appearing physically, said he's at a remote place where the internet doesn't work always, but I will convey and he will come back at 2 o'clock after lunch. Judge agreed, but the matter was not called, and he was online at 2 o'clock. Anyway, next time, the court issued notice and asked him to appear with his return tickets from wherever he is. So court was under the impression perhaps he is in the town, but he's not appearing, he's avoiding the court. So when this order was passed, it's very interesting. So we could apprehend something is coming. So the lawyer came with his tickets, and he showed the tickets and he apologized, everything. The judge was furious. And then it was a division bench, and the judge, incidentally a lady judge, she started dictating order for contempt of court, criminal contempt of court, directly, without issuing notice, without seeking his explanation. So then I appeared, I intervened. I said, Lordship, where is the rule of law? Where is the principle of natural justice being followed? You have not issued notice to him. You have not sought his explanation. You are directly implicating him for contempt of court. Court said, no, nothing doing. It's all there, nothing, you cannot. But I insisted, just give him one opportunity. And then other lawyers also joined, and they all insisted that one opportunity should be given to him. I said, we are not interfering with the merit of the case. You decide on merit, but give him one opportunity. After much persuasion, judges agreed, and he was asked to submit his explanation. And when he submitted explanation, he tendered his apology. He said, although this fact was disclosed in the petition that he had filed earlier petition also, but court was not accepting that, and they reserved the order. And then came the final decision, split judgment. One judge said, the lady just said, bar from few months, 1 lakh cost, and the other judge said, we believe in forgiveness. He has tendered apology, and these things do happen in this profession. So we accept his apology and we forgive him. There was a split judgment, then the judge who had sort of convicted him, she retired, and the matter went to 3 judges bench, different 3 judges bench. And it was recently listed. They accepted the judgment given by the judge who had forgiven him. Fantastic. So that's how the matter ended. So we do have a role to play. We do intervene when this kind of incidents do take place in the court. So bar associations are not sitting idle. They do take up these kind of causes. They have to be a spirit. I'm sure the leaders all have that spirit to defend our colleagues. Thank you very much. Sorry, I took the stronger time.
Thank you, Rachana madam. And now the concluding note.